Hi, 8th grade. Today we're reviewing Unit 4, How the Constitution Established Our Government. We have learned about the federal system, the ratification debate between the Federalists and the Anti-Federalists, the structure of early government, early arguments that led to political parties, and we will be learning about judicial review and Supreme Court interpretation of the Constitution. For the federal system. The federal system is a system of government in which power is shared between the levels of government. So, for example, the national and state governments share powers, state and local governments share powers, local and city governments share powers. Examples of this would be the United States, the state of Indiana, Hendricks County, and the town of Brownsburg. We learned that some powers are shared and some powers are exclusive. So examples of shared powers would be taxation. Every level of government has some form of taxation in order to pay for the services they provide. Some of these powers are exclusive. For example, the national government can make a post office and the state governments cannot. The people in a federal system are considered to be sovereign, which means they have the highest ranking. In a federal system, in our federal system, the people are sovereign because we wrote the Constitution, we have the power to amend the Constitution, and we elect our leaders, which keeps us in charge. This is the chart that we created in class. You are welcome to review this. Remember that the people do not remain powerless, even though it feels like we give away some very important powers. However, we retain powers such as the freedom to travel, to choose a job, raising a family, the freedom of belief. Powers that are very, very personal. There are three forms of government. There are federal systems, unitary systems, and confederations. Now, this does not designate whether it is a democracy or public or parliamentary system, but this refers to rather how the power of government is used. So in a federal system, the power is shared between the levels of government, between the state governments and the national governments. In a unitary government, power flows from the top level to the bottom levels. The national government is very strong, and it determines what the lower levels are able to do. Absolute governments, such as absolute monarchs and dictatorships, work in this way. Governments such as North Korea, as China, other monarchies that are absolute monarchies like Bahrain or Saudi Arabia, the monarch is mostly in control, and they determine how much the states and the people are able to do. In a unitary government, the national government can act directly upon the states. However, it does not mean that it has to be a dictatorship. Unitary governments are possible in democracies such as the United Kingdom. A confederation form of government has independent states that give power to a national government for limited purposes, usually defense and trade. Switzerland is a modern-day example of a confederation. The United States, prior to the writing of the Constitution, was a confederation-type government. The 13 states were very independent. They were small little republics all of their own, and they gave power to the national government on a very limited basis. However, under the Articles of Confederation, even though we felt by the time we wrote the Constitution that it was not a very effective government, we did win the war against Great Britain with this type of government. The Supremacy Clause. We talked about the Supremacy Clause back in Unit 1 when we discussed higher law. In general, the Supremacy Clause can be found in Article 6 of the Constitution, and it basically sets up the order in which documents or laws are important. So it puts the Constitution first. It says the Constitution and the laws of the United States, along with the treaties that are made, will be the supreme law of the land, and that is the hierarchy. The Constitution, then laws, then treaties. State laws fall even below that. The reason why this is important again now in the federal system is because it sets up the way that conflicts will be resolved if they arise between the levels. So if a state law conflicts with a national law, this is the way that it'll be resolved. Once the Constitution was written in 1787, it was sent to the states for ratification. Remember, ratification means to approve something. The ratification debate led by the Federalists and the Anti-Federalists. The Federalists were the people in 1787 who were in favor of the ratification of the Constitution. They wanted to see the Constitution approved. These include people like Benjamin Franklin, James Madison, George Washington, John Adams, people that were very happy about the writing of the Constitution. They believed that the national government needed to be very strong. However, it needed to be a constitutional or limited government. They thought that having separation of powers and checks and balances would be sufficient to limit that government. They also felt that a Bill of Rights would not be necessary. The Federalists believed that the national government was so checked and balanced that it would not be able to take away your rights. Madison argued repeatedly that a limited government did not have power to take away your freedom of speech or your freedom of religion. The Anti-Federalists, on the other hand, opposed the ratification of the Constitution. Some of these men did not attend the Constitutional Convention, such as Patrick Henry, who was the governor of Virginia at the time. Some did, like Gouverneur Morris. And as they left the convention, they were not happy with the document, and they became Anti-Federalists. In general, the Anti-Federalists believed the national government was too strong. They feared that it would become a monarchy, that it would become a dictatorship, that it would take away our rights. They felt that a Bill of Rights was essential to prevent the national government from oppressing the people. Remember that you don't have to remember the entire list. You don't have to memorize the list that's in your book. It would be good to reread. But if you can remember these very important concepts, you should be able to identify their thoughts. For political parties, after the ratification debate, the Constitution gets ratified, George Washington becomes the first president. During his presidency, Alexander Hamilton and Thomas Jefferson held different opinions on how the new national government should operate. Alexander Hamilton was the Secretary of State for George Washington. He believed the national government needed to be very strong in order to do its job. Thomas Jefferson served as Secretary of State for Washington. He believed that the national government needed to be limited and that states should remain powerful. Thomas Jefferson becomes the leader of the Democratic Republicans. Alexander Hamilton becomes the leader of the Federalists. Jefferson favored France. He thought that because they helped us first, that we should help them. They helped us during the Revolution. He favored the strong state government power with a weak central government, thought farmers were very important to the economy. He favored a very strict interpretation of the Constitution, therefore thought the Bank of the United States was unconstitutional. He believed that individual liberties should be protected by laws. He greatly disliked the Alien and Sedition Acts for that reason. He also wanted to lower voter qualifications, which again led to his dislike of the Alien and Sedition Acts. Hamilton, on the other hand, favored Great Britain. He felt like they were our first trading partner, therefore we should continue to trade and to have laws that favor them. Hamilton favored a strong national government. He thought manufacturing and trade were important to the economy. Again, this makes sense given the fact that he was from New York and he's surrounded by manufacturing trade. Jefferson was a farmer from Virginia. Hamilton favored a loose interpretation of the Constitution, so he really liked the Bank of the United States. He actually helped set it up. His argument was that if Congress has the power to collect taxes in the Constitution, therefore they would need a bank, and they would have the power to do that. He believed that individual liberties could sometimes be restricted when it was necessary. That was the Alien and Sedition Acts, and he also wanted to raise voter qualifications, so the length of time probably before you could become a citizen. The election of 1800 is mentioned in your book, and basically in 1800, this is when George Washington decides that he is no longer going to be president. He did not want to run for a third term, and he thought no one else should ever run for a third term. Thomas Jefferson is a Democratic Republican versus President or John Adams Federalist. John Adams was actually elected in 1796. So George Washington's president for the first two terms, then John Adams. This is John Adams running for re-election, actually. So he runs against Thomas Jefferson. And Jefferson wins the election. The reason why this is important, it's the first time we had a change in power. We went from having a Federalist president in John Adams to having a Democratic Republican president. And the fact that the transition of power was peaceful was a very significant development in our system. Political parties today, they definitely do fulfill a role. Your book gives you several reasons. The ones I chose as most important is basically through political parties, people feel like they have a voice in government. Working in those political parties helps you nominate candidates for different positions in government. These may be national positions, such as the president, or for senators or representatives, or it could be local government. Political parties help get many people involved, and a political party that is not in power can debate and criticize the party that is in power, and in that way bring forward a lot of ideas for people to consider. Judicial review. Judicial review will be talked about on Thursday. It starts with a case called Marbury versus Madison, and all of these people that you see on the screen are people that were very important in this case. And the story of this case is that President John Adams, a Federalist, had lost the re-election attempt in 1800. He was serving out the rest of his term, and in March of 1801, as he's leaving office, he appointed a lot of Federalist judges to the judiciary. His goal was to fill the judiciary with as many Federalists as he could. Secretary of State John Marshall, as you see him down there on the lower left, he was responsible then for delivering these commissions. So John Adams appoints them, the Senate approved them. It's up to John Marshall then to actually take the pieces of paper that were signed and sealed with the president's seal and deliver them to the appointees. So he's working very hard on this, and literally up until midnight, they call these the midnight appointments, he was delivering these commissions, and they didn't get done. William Marbury, that you see in the middle, he was a judge. He was appointed to a judiciary seat in Washington, D.C., and he did not receive his commission. So when we come later in March after the inauguration, Thomas Jefferson is president, Secretary of State is now James Madison, and Chief Justice of the Supreme Court is John Marshall. So the same John Marshall is now in a different position in government. William Marbury wants his commission. He goes to James Madison and says, "Let me have my commission." Madison will not deliver it. Jefferson has ordered him not to deliver the remaining commissions. They don't want any other Federalist judges in office. And so the president says, do not deliver these. So Marbury cannot get him to deliver it. Marbury, in turn then, under the Judiciary Act of 1789, goes straight to the Supreme Court and he asks for a writ of mandamus, which is an order for a government official to do his job. John Marshall, in the end, decides that the Judiciary Act of 1789 is unconstitutional because the Supreme Court does not have original jurisdiction in any case unless it involves an ambassador or two states. So the fact that Marbury went directly to the Supreme Court led to the defeat in his case. Judicial review is the power of the courts over the federal government to declare a law unconstitutional, to declare it null and void so that it cannot be enforced. We already assumed that they had this power over the state governments because of the Supremacy Clause, and Marbury versus Madison establishes it over the federal government, which greatly increases the power of the judicial branch. Lastly, how do justices today interpret the Constitution? There are 4 different methods outlined in your book that they use. One is the plain meaning of the words in the Constitution. What do these words mean? What do they mean by speech and religion and establishment? Another is the intention of the framers. They look at the different documents that were written by the framers and use that as a guide to understand what they meant. A third is that the idea that the Constitution is based on some fundamental principles of government, such as liberty and freedom. And the last is today's social values and needs.